Yes, Mr. Howe.
May it please your lordships, my lady, in this matter I appear for the appellant claimant, Thatchers Cider Company Ltd, and together with my learned friend, Miss Beth Collett, and the respondents, Aldi Stores Ltd, are represented by my learned friends, Mr. Michael Edinburgh KC, Miss Stephanie Wickenden, and Miss Neve Herritt. Just as a preliminary matter, in case it's of assistance to my lords and my lady, we do have in court some samples of the respective products.
Yes, well, I think we will certainly want to see those, thank you.
So at some convenient point, if they can be handed up. I
Yes.
wasn't planning to make a forensic examination of them at this point. So, if it pleases the court, my proposed course of action would be to start off with quite a close look at the judgment and its structure, and explain at a broad level where my grounds of appeal fit in, as it were, rather than elaborating them as I go through the judgment, and then pursue the grounds of appeal on the basis of the order in our appeal skeleton. My plan, unless I'm pointed in a different direction, would be not to deal with the respondents' notice points in my address to the court, and if appropriate, respond to them in reply, if that's acceptable, and also, in fact, not to deal with the application or suggestion to depart from the Court of Justice judgment in L'Oreal and Beaulieu, because again, I respect that's a matter for my friend to make out the case on, and then for me to respond to.
Yes, by all means.
Might be the most convenient course. So, if then, I apologise, I'm a slight tail end of a mild respiratory thing of the kind that's been going round. So if I cough from time to time, my apologies.
Understood.
Without more ado, then, if I could go to the judgment, which is to be found in the Court of tab 7. And really the opening parts, the introductory parts of the judgment just set out the issues in broad terms through to paragraph 7. I have no comment on at this, certainly not at this stage, in fact probably not at any stage. The first point I want to pick up is that from paragraph 8 through to 17, the judge went into the issue of what is the sign complained of in the pleadings, and she reached a conclusion at paragraph 17 that the sign complained of last sentence of paragraph 17, that the sign complained of was the overall appearance of a single can of the Aldi product, being the can, and indeed both faces of it, and disregarding, she held that the use of the similar material on the 4-can pack was not the sign complained of. Now, I challenge that on my grounds of appeal, but my proposal is, unless there's some concrete reason for it, not to develop that orally, simply because it seems to me, with respect that this particular finding, I can't see what part, if any, it played in the judge's reasoning under section 10, subsection 3. The only reference back to this, as it were, rather technical point point about what is the sign complained of that I could find was later on in the judgment of paragraph 74. Where paragraph 74, back over the page, page CB 119, the last sentence of that paragraph, Thatchers has chosen to plead its case such that I must compare two-dimensional mark being the trademark, which is not the Thatchers product, with the three-dimensional product being the sign, which is a single can of the Aldi product. That itself is a point of difference between the two.
Yes, well, you challenge that, as I understand.
I challenge it, and the grounds are set out in the skeleton. But the reason for not elaborating that is I can't see what, if any, part that particular observation played in the judge's reasoning under section 10, subsection 3.
Yeah, well, can I ask you a slightly different question? Because the judge appears to have focused on the question of what was the pleaded complaint. And she reached a conclusion on that question. But would you take issue with the proposition that regardless of what is pleaded as being the sign, at the end of the day it's an objective question for the court, and the court is not bound by what either party asserts to be the sign? See, for example, the Yorkshire Rosette case.
Indeed, I would accept and indeed endorse that proposition.
Yeah.
Which may helpfully short-circuit. On our case, it was comparing the whole for the whole, by which we meant, as it were, the whole appearance of the relevant side of the 4-can pack, or the whole appearance of the whole. Of course, what I appreciate one must compare with the registration, the representation, the registration.
Yeah, well, you make the point that the trademark in use is wrapped around the can.
It is wrapped around, so it's on a cylindrical surface, so it's actually, depending on how you look at it, two-dimensional, but wrapped on a three-dimensional surface. I hesitate to spend more time on this because I'm not sure that this particular area of discussion of two dimensions versus three dimensions affects any real issue. When people buy products in round things like cans or bottles where labels placed, customers expect to see, as it were, two-dimensional labels wrapped around three-dimensional surfaces. It doesn't really impinge on the way, my submission, that members of the public assess them or look at them. And it's just very common practice, as here, to have effectively the mark repeated on the front and back, so whichever side you happen to be looking at the can, you can see it. Now, that at any rate, so if I can pass on from that.
Yeah.
And go back to the judgment, earlier in the judgment, after the end of that section, she then starts on an assessment of the witnesses. Sorry, after that, there's a list of issues which, in paragraph 19, which I will come back to briefly in the context of one of the grounds of appeal, but I'll pass over that for now. But at 20, she assesses the witnesses that over the top of page CB 95, Mr. Milton was held to be straightforward, credible and reliable. And as regards Mr. Watkins, the upshot is in paragraph 23, towards the end, although he made concessions, she points out, accept his evidence as both credible and reliable. I thought Mr. Watkins has a tendency to provide answers to questions that were not asked. In doing so, avoid questions that were. I do not think that this is deliberate. As after I'd reminded him to listen to questions and answers there directly, he did so. So that's the findings on the credibility of the witnesses. She then, after that, she comments on Mr. Lane's evidence about what he picked up in the IPO, but I think that's relevant to anything if it's the respondent's notice. She then goes on to a description of the factual background dealing with Thatchers, of which I have very little issue with the findings in the factual background. No specific issue with them. She fairly summarises the steps that were taken to, as it were, create the Thatchers brand and the trademark on the can, and the steps taken to promote and market it, which were extensive. Just on paragraph 28, a point I'd like to pick up, where she annexes to the judgment a number of figures. Now, they are somewhat in somewhat reduced size in the transcript of the judgment itself at the end. These have been increased in size, and it may be more convenient for my lords and my lady to look at them in the, as it were, increased size versions. At the beginning of the supplementary bundle, in fact, because what we've done is, what tends to happen with these cases is obviously the important pictures get scattered around and end up at the back of bundle 7 or something, and we sought to collect them together, the key ones, and provide as good quality copies as possible. The third-party products ones, tab 5, they begin, and these are reproductions of better size and scale of the judge's annexes. And of those, these came out of Thatcher's disclosure and were part of an exercise when Thatcher's were considering launching the lemon-based cider product. They did quite extensive market research, which involved looking at all sorts of lemon-flavoured drinks on the market, not just cider, but other alcoholic and non-alcoholic lemon-based drinks. And as a result, and the judge has annexed them, that there's quite a collection of different lemon-based products that one can see, starting with starting with tab 5, which is, sorry, the table of contents actually tells you which annex of the judgment it is. That is the judge's figure 2. Then figure 3 is core image 6. That's on the core image. first one, core image 5, one can see the brother, or a version of the brother's product, which is a cider and has a lot of cloudy lemon cider, has a lot of lemon on it. But obviously a point my clients would make is the difference. You can have lemon or a lot of lemon and present it in very different ways. The only exception at this point for the one at tab 7, core image 7, is a product that was sold by Aldi in their store. So that doesn't come from Thatchers disclosure. And then, which is in bottle product rather than in can. And then going back, the next one, core image 8 again, is from Thatchers disclosure, as is core image 9. So they're all done prior to the launch on the market of the product in question, Thatchers product in question. And then she just 31. She begins discussion of the trademark. Again, I don't have any issue with these findings. In fact, as it was, my case relies on them. And it goes both to the issue of making the trademark attractive to consumers, and a lot of design effort being put into doing that, and also to the promotion of it. For example, in paragraph 33, she points out that the design, the overall look and aesthetic of the Thatchers product is deliberately different from the other products in the Thatchers range because of the departure they're making a non-apple cider. And so on. Now, marketing and sales, she goes on and deals with. And at 41, just before she leaves Thatchers, she accepts the evidence that since its launch, Thatchers has sold 11.6 million litres of Thatchers product. That's up to just shortly before the trial this last year, and that coming to £29.6 million in sales at retail, and very, very heavily promoted as well. Now then, paragraphs 42 through to 53, she deals with the subject of benchmarking by Aldi of the Thatchers product, or at least the Aldi and the Taurus range begins at 42, and at 45 she addresses the subject of benchmarking. And she makes a finding, quite an important finding at paragraph 50, that contrary to Aldi's initial position was that they benchmarked the Thatchers product as regards flavour only. However, that, with respect, was unsustainable on the basis of their disclosure. And she makes a finding at paragraph 50 that it seems clear from email communications and members of his team that when making decisions about various design options and iterations, those decisions were being taken with the Thatchers product as a reference point. The early iterations very much in the house style, Taurus house style, the Taurus brand, bull's head device. price. Swoosh, yellow, green and white. He said in his written evidence he did not consider his early versions to do a good enough job of communicating the lemon flavouring or the more premium nature of the product. So he wanted package design that should be shouted lemon to consumers, to communicate more value to reflect the higher price of seasonal flavours. For that reason, he asked Black Eye Project, the design house, to add pictures of lemons like Thatchers, because he thought the Thatchers were doing what Thatchers were doing with lemons to communicate exactly what the Thatchers product was excellent and subjectively better than the Brothers Cloudy lemon cider, for example. And accordingly, the instructions came from Mr. Watkins' team to the Black Eye Project. They wanted to see a hybrid of Thatchers and Taurus, i.e. a bit more playful, add lemons as per Thatchers. And in my judgment, that is using the Thatchers product as a benchmark for the packaging. So obviously that's a finding that I rely on and I will come back to in the context of Section 10.3 infringement, in particular unfair advantage. And in 51, again, as a slightly later stage of the design process, she makes a finding at the end. Last sentence, in my judgment, that admission that one of the reasons he preferred the whole lemons is because that is what was on the Thatchers product is again evidence that Aldi was using the Thatchers product as a benchmark for packaging. So, however, I'll come back to this when I come in the specific grounds of appeal. Now, going forward, paragraphs 56 through to 60, she deals with the evidence of sales of this product, this Aldi product versus other Aldi products. And I'm just noting that passage in the judgment at the moment because that forms one of my grounds of criticism. There's then, from page 1, paragraph 61 onwards, discussions of the law, which I don't challenge. And indeed, since there is no appeal against her finding on Section 10, subsection 2, infringement, in other words, her finding of no confusion, there's no, as it were, challenge to the reasoning leading to that conclusion. The only point I pick up at this point, though, in passing, is paragraph 75. Where which deals with the issue of Aldi's intention. And I'm going to, obviously I'm going to deal with the judge's treatment of intention, but the claimant Thatcher's case did not allege that Aldi intended to cause confusion. That was not alleged. What we did allege is that they intended to make it similar to cause a link and benefit from the link. So that was the intent we were pursuing. Which is, in my speech, it's a significantly different intention, or an intention to cause confusion or cause deception in the context of passing off. Because that intention is well known to be a form of fraudulent intention. intention to arrange things so customers be actually deceived. The intention to make your goods similar and gain benefit does not fall into that category. My submission is not fraudulent in any way, whatever some people's views on it may be, as a desirable or undesirable commercial practice. And in paragraph 5, she makes a particular point about one point we had relied upon was the appearance of faint horizontal background lines which are in the trademark, and the appearance of similar horizontal lines on the Aldi can. And she says she satisfied those lines are so faint they would not be recalled as being present on the trademark by the average consumer. That's a proposition we would not dissent from. However, I'll come on to this, but we do have an acceptance in Mr. Watkins' evidence that they would subtly alter the texture compared with the background, compared with the flat, plain colour texture. But the real point here is that she dismissed the relevance of this, whereas in our submission, when you are considering the issue of has there been copying, telltale signs, even if insignificant in themselves, are often powerful evidence that copying has taken place, that there's been close attention paid to the product, and then one asked why. So the one has to ask why. So there's a significance to them, to this, which goes beyond their significance in the appearance of the product, respective products.
Which part of the test does that you say that significance go to? Which is it? The link? Is it the advantage?
It's the. I think when I come to it, it's the unfairness of the advantage. That there are two ways in which this is an interesting issue which I'm going to address, but maybe I can just...
Sorry, you take it in your...
Well, no,
I just wanted to understand where you might go with
Well, it's quite helpful to just outline it here, because it's well established in authorities that an intention to cause confusion is evidence from which the court may infer that the trader has succeeded. So it has an evidential effect. But it's not necessary to the cause of action either in passing off or in section 10 subsection 2 confusion trademark infringement. And indeed it appears it's evidential only in the sense that if you sell the same good, the identical goods, and one person is selling them with a bad intent and the other isn't, it doesn't make a difference. The intention goes to evidence, not to making a otherwise lawful act unlawful. Intention in section 10 subsection 3 on the basis of the L'Oreal and Bellier case is a more complex subject. And I think my friend's skeleton suggests it's rather like it's evidential only. With respect, I'm not sure that the L'Oreal and Bellier case reflects that. And it may well be that the right answer is that it is relevant to the fair, it may be evidentially relevant to whether an advantage is gained. One can see that because if the trader is trying to make goods similar enough to competitors, one can infer from that that the trader expects to gain benefit. So it's certainly evidentially supportive of a case, and it may also have a constitutive effect to the cause of action in the sense of making it very difficult for the trader then to argue that the advantage is not unfair. Because there are two elements in unfair advantage. There's gaining the advantage, and there's whether it's unfair.
Surely unfairness has got to be judged against some objective standard, can't it? The fact that you intended to do something that isn't objectively unfair can't make it unfair.
Well, that may be right, but perhaps I will come to this point by reference to the L'Oreal and Bellure case. And in fact, my Lord Justice Arnold also addressed this in the Jack Wills case, and looked at both that authority and other English authorities of intent in this context.
Right. Well, so we'll come back to that later.
We'll come back to that. So at this stage, it may be intent in section 10.3 may be more than evidential. It may be. But at any rate, it can be significant, which is why we pursued this at trial.
But at the moment, all that you're saying in relation to the faint horizontal background lines is that they indicate intentional copying.
Yes.
So, and from that you then infer something more.
Yes, it's obviously it's not the only factor. I mean, there's a lot else, but we would say casts a light on the level of attention that was being paid to the Thatcher product.
Okay.
Now, to carry on pressing on with the judgment, her finding at she then deals with the subject, or she goes on and deals with the subject of similarity between mark and sign. And her determination is at paragraph 78. And she's satisfied the dominant elements of the trademark, the central element made up of the Thatchers brand with the cloudy lemon cider in large and decorative font underneath. Less dominant but also important are the whole yellow lemons with quite large green leaves dispersed around the top and left edge and creamy yellow colourway of the background. So they're still important. And then her equivalent assessment of the sign, Aldi sign, is at paragraph 81. Where she says the dominant elements of the sign are the central element on the front and back of the can, which is made up of the bull's head device and the brand Taurus beneath. And then also important but not dominant are the yellow, green and gold swoosh emanating from the bull's device as it curved both upwards and downwards. Also on the front and back of the can, and the whole yellow lemons, and so on. And then nuance, don't find the green leaves to be as important in the sign as in the trademark, part because they're smaller and detached from the lemons, part because there are additional green in the sign relating to the swoosh, which makes the leaves less important. Now, to note there that she assessed as being the dominant elements, if you like, the brand elements, the Taurus with the head, and Thatchers, well, so the cloudy lemon below it, and that was done in the context, and one can see in the context of section 10.2 infringement, whether or not there's confusion as to brand origin, the importance of that in her assessment. And she reaches the overall conclusion at 89, taking all this into account, in my judgment, the overall appearance of the Aldi product being similar to the sign, being the sign, is similar to the trademark, but to a low degree. Now, I do have a challenge there in my grounds of appeal, not to her approach under Section 10, subsection 2, but in effect because what we suggest is that she transplanted this low degree of similarity into Section 10, subsection 3 assessment, when in our submission she should have, as it were, thought about it again, because taking the difference in the brand names, now that is obviously very significant in the context of confusion, that if people see there's, oh, it's Taurus, it's not Thatchers.
Yeah, so the submission is that one doesn't ask whether signs are similar to trademarks purely for academic purposes. The question is, are they sufficiently similar to have an effect? And in the Section 10.2 context, the question is, are they sufficiently similar to give rise to a likelihood of confusion? In the 10.3 context, the question you say is different. Are they sufficiently similar to give rise to one of the specified forms of injury?
Correct, my lord, yes. So my criticism is if you like, not re-ask or asking the different question, having gone through the similarities.
Do you have, I'm sure we'll come to it, do you have case law support for suggesting that the difference of approach of that nature?
I will come to it. There's an observation of Lord Justice Kitchen, as he then was in Specsavers,
right,
which I say suggests they're two separate assessments. Two separate assessments. But I will. I'll come to it. Otherwise, I'll end up opening my entire appeal before I reach the end of the judgment.
Yeah. All right. Next.
Next. So next, if we come for, yes. And just to note, well, from paragraph 1991 onwards, 91 is enhanced distinctiveness of the trademark, where she dealt with a submission by Aldi, which basically they were challenging whether the trademark, i.e. the whole trademark, had anything to it more than just the Thatchers name. I don't challenge this, indeed I rely on this, but this is subject, I think, to the Respondent's notice challenge.
Yeah.
And a conclusion on that is paragraph 99. That the relevant date on which the Aldi product was first offered for sale, the trademark, that's Thatcher's trademark, had enhanced distinctiveness because of the extensive nationwide use that Thatcher's had made of it. She then goes on to factors relevant to context, and this is context for her confusion assessment. And since my clients are not appealing against the finding, I'm not making any challenge to this part of the judgment. And then over to paragraphs 107, and then there comes points where, on intent that I do need to comment on. So she holds at 107 on page 134 that the actual evidence confusion is lacking. Now this is where she starts dealing with the issue of intent. Now, we, as I say, we had not alleged an intention to cause confusion. And therefore, strictly speaking, what we had alleged was different and relevant to Section 10, subsection 3, rather than Section 10.2 confusion. What was to make the appearance of the product closer. Now, she records in my submission about, which was certainly intended to be a submission in respect of intent in the context of Section 10, subsection 3, she records that in 108, but that she's concerned with the final design of the product. And then on 109, she says the question of intention comes into both an assessment of likelihood of confusion, Section 10.2b infringement, and also unfair advantage in Section 10, subsection 3 infringement. And he quotes Mr. Alexander in the Planet Art case. And what's slightly concerning here is that Mr. Alexander's, this particular part of Mr. Alexander's judgment is concerned with Section 10, subsection 3 intent. And he makes the point it may be hard evidentially to disentangle the defendant's intention to copy a claimant's business for an intention to benefit from the claimant's reputation and goodwill. In one sense, any rival trader who's adopting similarities in approach and presentation of the business is intending to benefit from that. But a court must be astute not to confuse that with the more specific intention to benefit from the reputation and goodwill of the registered trademark. A fair observation, but it's puzzling as to why it's in the lead up to the conclusion on Section 10, subsection 2. She then goes on in 110 to indirectly via Mr. Alexander's judgment to refer to the well-known Mr. Justice, I thought he was Mr. Justice and Lord Justice at that point, sorry, I can't remember, Mr. Justice Kitchen in Specsavor, comment, he has appreciated the risk of confusion.
It's Lord Justice, but it doesn't matter.
He was Lord Justice.
He was in the Court of Appeal.
Yeah. Was a Court of Appeal, Spectator, yes. Well, she comments on that, appreciated the risk of confusion, has endeavoured to adopt a sign which is a safe distance away. And she says she'll come back to Planet Art in my consideration of intention to deceive in respect of Section 10.3 Trademark Act infringement.
Yeah, and you say that wasn't the allegation.
That's not an allegation. It's not an allegation of deception. So it's not totally clear what this is doing at the end of the Section 10.2 analysis, but at any rate, since we don't challenge the ultimate, and she says at the top of 112, next page, 112, paragraph 112, the fact that the average consumer may look at the sign and bring to mind the trademark on the Thatchers product is not sufficient confusion, which is clearly a correct proposition, that bringing to mind is not itself enough to lead to confusion. And in my judgment, there's no real likelihood of the average consumer taking into account all those circumstances which are likely to operate in his mind, and the impression that the sign is likely to make on him will be confused. Accordingly, the claim for infringement is dismissed. And again, we don't challenge that dismissal. Now, she then moves on to the to section 10 subsection 3 and deals with the first issue in that context, which is whether the mark has a reputation, being a necessary ingredient for infringement in section 10 subsection 3. In effect, in repeating, she earlier obviously considered that the reputation in the context of enhanced distinctiveness, and she comes to a similar conclusion, and in paragraph 115 towards the top of page 137, she rejects Aldi's submission as unrealistic, not supported by Aldi's own evidence that improving the design of its packaging would improve the attractiveness of Aldi's products to consumers and enhance sales. That principle, surely a basic principle of marketing retail goods such as these, must equally apply to the Thatchers product, which Mr. Watkins, that's Aldi's witness, thought did a very good job using the whole lemons in its design of the trademark to communicate to customers exactly what the Thatchers product was. And that is why one of his team members emailed all these third-party packaging designers to say, add lemons as per Thatchers. The presence of lemons was attracting custom, I agree. And that's in the context of the reputation of the mark. Now, then issue 4, the link, the finding of a link. And this again, this is an aspect of the judgment upon which I do rely. I rely on her finding that the average consumer, on seeing the Taurus product, would bring the Thatchers trademark to mind. And it's also, I'd also, with respect, say that the nature of the link is itself relevant to the next step, which is unfair advantage. Because it goes beyond calling it to mind, oh, I can see there's some resemblance. The evidence she founded on, she recites the top of paragraph 118, contains phrases such as it's a Thatcher's lemon cider rip-off. The actual, where she got this from can be found in supplementary bundle tab 17, which are the social media posts. That's an annex here to page bundle, it's tab 17, bundle page 25 begins. They're quite there are not that many of them. But in my submission, it's quite powerful in the sense of connection. First one is somebody who's Richard is drinking cloudy lemon by Thatchers, Boothie's Bar. My kids would call this the non-knockoff version. I don't take them Aldi anymore. This is a bit more lemon tartness that I'm sold. Then we have a page 26 to 27. Again, a couple of posts on Untapped. One of them says left-hand side, it's a bit I prefer Thatchers to this. That's the Taurus. Opposite page.
I don't know if you intended to skip over 26, where we have very good Thatchers lemon cider rip-off.
Yes, sorry, yes, I should have picked that up. Yes, very good.
Yep.
Yeah, that's the source of the word rip-off that she quoted in the judgment. And then, sorry, I got to page 27. This is a bit near Thatchers. And the right-hand side, not quite Thatchers lemon, but half the price. There's not to complain of. Fruity, drier peach. And the last page, page 28. Not as good as Thatchers, but still decent is the first one. And spot on, tastes as good as Thatchers, and is £1.50 cheaper for 4 cans. Winner. And now the judge, as it were, discounted some of these as indicating perhaps just a comparison with Thatchers as the market leader. However, paragraph 121, she said there's some evidence in comments about the Aldi product being a rip-off, knock-off of the Thatchers product to support Thatchers' case. Those consumers would not make those comments if they merely thought that both the cloudy lemon ciders, of which there are others on the market, they appear to have seen the sign, which is a can of the Aldi product, that's brought the Thatchers product, which bears the trademark, to mind. And taking all relevant considerations, so she finds over the page, I'm satisfied on the balance of probabilities that seeing the sign would call to mind the trademark. Now, then, she then goes on to deal with the unfair advantage issue, paragraph 123 onwards. And in fact, she refers across to Mrs. Justice Smith's review of the authorities in Little, to which I take no objection. And then we come on to, in terms of a summary of the law, I don't challenge, in effect, a summary, 123 through to 126, notably 125. She refers to Jack Wills and House of Fraser, that an intention to take advantage is neither required nor determinative. And finally, 126 is, she records the overall global test, global assessment. Again, I don't dispute there's an overall global assessment, but my criticism is to the, as it were, to the inputs to that assessment as carried out by the judge. But I'll address this head on when I come to the ground of appeal. But I just want to pick up the way she deals with intent, because it sort of weaves in and out again here. Because paragraph 130 at the bottom of page 142, she refers back. That I consider in the context of likelihood of confusion, Thatcher's submission that the documentary evidence relating to Aldi's design process and Mr. Watkins' evidence of changes should lead me to find that Aldi had an intention in designing the sign to benefit from Thatcher's reputation, goodwill, and the trademark. I've already found that in my judgment, Aldi, through Mr. Watkins, has endeavoured to adopt a sign which is a safe distance away. Referring to Mr. Alexander Casey's consideration of the problem, rather confusingly, she now she's on definitely section 10, subsection 3 confusion. She quotes a passage from Mr. Alexander's judgment, which is to do with intent to cause confusion. Which there's a fundamental difference between defendant's intention to copy a claimant's business, defendant's intention to represent falsely. It is all connected with the claimant. And the issue of safe distance away, of course, it depends what you mean by safe distance. Safe distance in the sense it's safe, I don't think people will be confused, is one thing. And that seems to be what she's discussing here. It doesn't follow that because you think there's a safe distance on lack of confusion, that there's a safe distance in the sense of calling the mark to mind and obtaining an advantage in the market from that. And then her finding, I go to the next paragraph now because on intent, in 131, she's drawn from it, from Mr. Alexander, the reliability of witness evidence and assessing the defendant's intention. However, in this case, in my judgment, Mr. Watkins' evidence that his intention was the Aldi product should be clearly understood as a Taurus branded cider is supported by extensive use of the Taurus brand, bull's head device and the swoosh on the front and back of the sign, as well as those things which provide context against the sign was intended to be seen by consumers, cardboard packing of the 4-can pack and the SRP tray. There was a tray on the shelves which had the Taurus and the bull's head on it when they presented. Also supported by the low degree of similarity of the signs of the trademarks I found. And on balance, I'm satisfied Aldi did not develop the Aldi product being the sign with intention to take advantage of the goodwill and reputation of the trademark. Now, so she's founded that in effect on an intention it is seen as Taurus branded. And in my submission, that misses the point. But I'll come back to that in the context of intention, but leaving aside intention at the moment, she goes on at 132, correctly, notwithstanding that finding, is the objective effect of the use of the sign such as to enable Aldi to benefit from the reputation and goodwill of the trademark. And in 133, she rejects my submission that the packaging would be expected to cause a change in economic behaviour, in view of the repeated changes in the work they've done it. She says, I pointed out in closing, surely all design decisions in relation to the look of packaging, where not legally mandated, are intended to make the products more attractive to consumers, encourage sales. The question is whether similarities I've found between the sign and the trademark cause consumers change their economic behaviour, the likelihood of change not being relevant in this case, where the Aldi product is no longer on the market. That has not satisfied me. This is the case. I've stated the evidence of sales achieved by Aldi from the Aldi product, which is the sign, do not look disproportionate in relation to sales of other ciders in the Taurus family. Mr. Milton's evidence, they were astonishing, they only result from unfair advantage resulting from Thatcher's investment in the amount to little more than supposition in my judgment. And then she goes on to the global view. Now, this is really, I suppose, the heart of my unfair advantage ground of appeal. What she doesn't do is consider what I call the transfer of image issue, which is leave aside the quantitative comparisons for the moment, assuming that they don't prove anything. Other courts and tribunals have been quite prepared to find that consumers will change their economic behaviour in the sense of being reassured by the familiarity of the trademark with the trademark they, as it were, previously know and love, in order to, and that is likely to enhance sales of the defendant's adopted trademark, which creates a link. And I respectfully say that there is a gap here, that there's no addressing, certainly in the express terms of the judgment, of the issue of transfer of image and the likely benefit that a trader will get from achieving the similarities, the perception of similarity, which in my submission are findings on the link, establish that the average consumer will have. She then, the final wrap-up is effectively on unfair advantage is paragraph 134, which is a recitation of the factors that go into global appreciation. Trademark as a whole has an enhanced level of distinctiveness because of the level of that trade and promotion marketing. I've also found that it has a low level of similarity with the sign. So this is the point at which I would say no reassessment of the degree of similarity in the context of section 10, subsection 3. Then she says, I found that elements are not distinctive because they're descriptive in text, or ubiquitous, the limited coloured palette, or commonplace, the use of lemons on lemon-flavoured beverages. I mean, again, this may be nitpicking, but our case was never that just using lemons as such was objectionable either in the context of 10.2 or 10.3. It's the combination of the way they're presented, looking at it in combination as the consumers who provided evidence of the link would have done. And she then goes on to tarnishment, and then she deals with tarnishment, which is a separate topic, another, again, a ground of appeal. So I think that, sorry, it's taken the time to go through the judgment, but it may be helpful in shortening the way in which my individual grounds of appeal can be dealt with and feed in, as it were, to the judgment.
Can I just ask for help on one thing? I'm sure it's just my lack of knowledge. That the statutory wording is, without due cause, takes advantage of.
Yes.
But the judge in issue 5 has seamlessly changed the wording to take unfair advantage. And that's the word she uses in the heading and several.
I see. The without due cause has been elided in effect.
So is it that she takes, or the authorities taking advantage without due cause means unfairly taking advantage?
Well, I guess this gets us squarely into the problem that we discussed in Lidl and Tesco, because the problem it gives rise to is the proposition that you can take unfair advantage with due cause. And it's conceptually very hard to understand how you can take unfair advantage with due cause. And that was discussed in the judgments in Lidl and Tesco. I mean, this is not a matter for you, Mr. Howe, because you don't have to. You don't have a ground of appeal on this because there is no finding of due cause.
No.
Is there a respondent's notice on due cause? Remind me. I think there is, isn't there? But then, so it's a matter for Mr. Edinburgh.
My lord, if I may address that.
Yeah.
With respect to due cause, then those words themselves, no. But it might arise in slightly different context with respect to the respondent's notice point 5, the 11.2b.
Oh yes, thank you. What I was thinking of. Yes, I was muddling the two. Thank you. Yeah. So we don't need to worry about due cause. Is the bottom line.
I hope so. I think that's right, my lord. Yes, it's the contradiction of it has to be both unfair and without due cause. Reading literally the wording of the statute, which is based on the directive, the EU directive and regulation.
Also, that was my point. I don't think the word unfair appears in the statute.
Yes, it does.
Oh, it does.
So, sorry, I had to double.
That may be where I'm going wrong then.
No. Yes. Takes unfair advantage, yes. Yes, there is one possible explanation is that there might be cases where a defendant, say because the defendant has previously used a particular mark and built up a reputation under it, might have a due cause to carry on using it, even though it later, continued use of that mark later causes, in effect, a link and unfair advantage.
Yeah.
But I agree with my lord that perhaps we can avoid branching off into that interesting topic, but not necessary.
Oh, I see. I think it's simply that the judge has admitted the word unfair in her quote from the section.
Sorry. I'm afraid I hadn't noticed that initially myself.
The human eye sees what it expects to see,
Yes.
and hence it takes those who don't have an expectation to notice the omission.
Indeed, my lord. Anyway, that then brings me specifically to the grounds of appeal which I intend to follow in the order of the skeleton. And therefore, the first ground which I will come to is the finding that Aldi, in adopting this design for their Cloudy Lemon Taurus product, had not significantly departed from its house style. And we start off with the house style.
You say there are two big differences. One, there's no black, it's white. And two, suddenly you've got fruit all over it.
Those are the major differences, yes.
Yeah.
And I mean, the strong mode, there's also the strong mode connection. Whether it's technically, I mean, the strong mode connection perhaps is more relevant later, but nonetheless, it does actually explain the house style. And contrary to my friend's suggestion in the skeletons, that this is some sort of new point, the house style being the torus being derived from Strongbow was in the particulars of claim. That's at Core Bundle, page 163.
I assume the pictures that are shown in of that, showing the comparison with Strongbow, were
Yes.
before the judge.
They're in fact, they're from the annex
Right, so
to
it's
the particulars of claim.
13C.
13 subparagraphs, yes, they're referenced in paragraph 13C.
Comparison to the Strongbow products. So where's the antecedent for that? That suggests that they've been referred to previously. Oh, it's B. Sorry, I was looking straight past it. Yes, 13B.
These products are highly similar in appearance to the corresponding products
Yep.
of the well-known cider manufacturer Strongbow.
Yep.
And the picture, the best picture, again, the best picture is in the core bundle. It's reproduced from Annex 3, particulars of claim, which is at tab 4 of the supplementary bundle.
Sorry, Michael, I don't have tabs in this.
I apologise. I'm not sure.
Just
Is
It's
my lord
page
using-
4.
Page number will be fine.
Oh, page number. It's page numbers SB4 and SB5.
Yeah, so that's Annex 3.
Which is Annex 3 to the particulars of claim.
Yeah.
Presumably the design is meant to evoke Strongbow, but presumably the use of a bull is meant to evoke another cider manufacturer.
Yes, indeed, and obviously the trademark itself, the word Taurus, is obviously different from the word Strongbow. And the bull's head, again, is related to Taurus. Strongbow has a sort of quite a different device, which I think is some sort of bow and arrow device above the word Strongbow.
Well, it's a stylised archer.
Stylized archery. And there is a difference in the style. I mean, the most notable difference I would suggest is in Strongbow you have what one might call a single swoosh. It just goes round in one arch, whereas in the Taurus range they've created a sort of double arch effect, where the swoosh comes in towards the bull's head and then goes out again and back again towards the bottom.
Yep.
So, that's the that wasn't challenged. Sorry, I should say in the defence it was denied. It was a denial, I should say, to be accurate. There was a denial of that paragraph of the particulars of claim. However, there wasn't any challenge in evidence, and indeed Mr. Watkins, Aldi's witnesses' witness statement at 2 points referred in terms to Strongbow being the benchmark for the Taurus range. That is at supplementary bundle. So I'm sorry, I've got the tab number here, but that is paragraph 11, which is on page 75 of the supplement bundle.
Strongbow used as a benchmark when developing Taurus.
Correct,
Right,
yes. There's another stray reference to it in paragraph 21 of the same witness statement. It really effectively says the same thing. That's page 76. Benchmark product for the Taurus range should be Strongbow. They didn't have a
Yes,
cloud
well,
product with their
that's, if anything, stronger in your favour because it uses the definite article as opposed to the indefinite article, as in the previous reference.
The benchmark product, yes.
Yeah.
Yes. So no other benchmark suggested. My client's witness evidence also adverted to this, and on this aspect, not cross-examined as far as we can see. Mr. Milton's witness statement, which is tab 24, and let me give the page number for my lord. It's paragraph, it's page 80, bundle, paragraph 11 of Mr. Milton. It's just a comment, really, that using a benchmark product range is ubiquitous practice by retailers when developing own-label brands. As I explained, it was therefore not surprising to me Aldi used the Strongbow range as their benchmark for its Taurus range. Accordingly, their range of own-label Taurus cider products uses the same overall appearance, colours and flavours as Strongbow. And then he goes on to make a comment about the product in issue. There's been divergence from that appearance of the range.
Yep.
As we say, we think Mr. Milton not challenged on on his comments about the similarities between Taurus and Strongbow range. And there's a presentation, in fact, which is relevant on Cloudy Lemon Taurus versus the rest of the range, which is in supplementary bundle tab 12, page 13.
Yep.
And this then comes on to what one is sort of going on perhaps to matters of comment. Well, no, it's worth looking at the design process. There was progressive departure because if I go to supplementary bundle, page 188, which is Yes, that's tab number 43. This is Aldi's first design iteration.
Yeah.
And
Market review, one product.
market review, one product. Indeed, that is a point we we of course adverted to, but their market review, in fact, interesting. They show the product both as a single, Thatchers product, both in its single can, and also the 4-can pack is also depicted. So the initial version in fact, there were two variants here, which were somewhat different colourways.
Yeah.
But no fruit. One can see the resemblance stylistically to the rest of the Taurus range. Although perhaps a big difference is the disappearance of the dark central beam, the dark colouring of the central beam.
Yeah, well, you can see that at 197. Yeah.
One can see that, and then, and of course, then there was successive changes. The addition of the fruit was important, and we say not just.
Yeah.
I mean, these actually, once we're in the design process, it's quite quick to just sort of flick through this.
Yeah. So the next iteration is 198 and following.
Yes, just before 197 is interesting because it shows the new proposed design against the existing range.
Yeah.
Then there's the next iteration. I think, yes, there's some fruit at this stage. Page 202, there are a couple of cup lemons, or one partial cup lemon at the bottom that appeared. In that variant. And then the alternative variant, page 204, that the whole lemons with leaves. Here, and they chose, obviously, they chose the whole lemons, accepted as being more objectively similar to the Thatcher product. And then there are further developments in the iteration that begins at page 209.
Yeah.
3. In fact, the final design is quite poor in the bundle. It's just, sorry, it's quite poorly presented, that's all. It's just difficult to follow at page 220 because of the way it's an artwork being sent to the printers. So it may be best to look at the actual product as the definitive appearance of the final.
Quite interesting that it's only right at the end that the big lemon at the bottom overlays the swoosh.
Yes, now we of course we make a point about that because our contention is that suppressed the appearance, it made the swish less apparent. It is correct that on the Thatchers can, Thatchers doesn't have a lemon in that corresponding position.
Yes, but you make a different point,
yes,
which is clearest. Maybe you can see the contrast on page 218. The penultimate version. The swoosh is very obvious in that, and perhaps less so in the final.
Yes, my lady, that's right. It certainly does. it's much more evident that that the green is part of the swoosh. But once you get to the final torus can, well, there's a little bit of the swoosh left, a little bit there, and a bit of a green leaf sticking up, and so on. Sorry, I'll hand these up at some point. My lords might, my lords and my lady might want you to look at them, but
Yes, well, we can look at them outside court.
yeah. So, what this comes to here, and I appreciate that, as obviously very recently reiterated in this court's decision in Tesco and Lidl, it's a high standard to ask this court to overturn a factual finding of the trial judge. But in this particular case, the finding is, if you like, in my submission, what the judge is doing here is placing herself in the shoes of the average consumer, which is part of the judicial function in trademark and passing off cases. You don't normally call expert evidence about how ordinary consumers behave on ordinary goods. It's for the judge to assess. However, this isn't an instance where it's a conclusion based on the judge evaluating a lot of evidence, being immersed in a big trial, which the Court of Appeal can't.
Oh, it's a straightforward comparison. Between the products.
And I do submit that what she has done in finding there's no significant departure is in the realm of being unsupportable and does call for, in my submission, for reversal by this court.
Okay. Next.
I think if the court has my point, I think that there's not much more to elaborate.
It's yes or no to that.
Yes, or you either agree or you don't. Having pondered it and looked at it and heard, of course, what my friend has to say. So, that brings me to the next ground in the skeleton. Which is the issue of the low degree of similarity, and this does contain a point of law.
Yes, you mentioned earlier you were relying on spec savers.
I'm going to suspect savers, yes. Can I just look at the statute first?
Yep.
I know it's unfashionable to look at statutes, particularly in property cases, but
it's always a good idea to be reminded.
The judge hasn't said that.
So it's Authorities Bundle 1, tab number 3, and section 10, which is the infringement section of the Act, appears on page 19 of the bundle, according to the bundle numbering. And as it were, there are three prongs to infringement. The first is section 10, subsection 1, which is identical, sign and mark are identical. So similarity doesn't come in at that point, they are identical. Subsection 2 is interesting in the sense of how it asks you to, or how it directs you to apply similarity or dissimilarity. The way it's phrased, a person infringes a registered trademark if he uses in the course of trade a sign where because, so the operative word is because, and it's B that we're talking about, because the sign is similar to the trademark and is used in relation to goods or service identical or similar to those goods, there exists a likelihood of confusion on the part of the public, which includes a likelihood of association. So there is a threshold here. I mean, there must be some degree of similarity, but it's a low threshold, and it may well be the same low threshold in subsection 3. I'm not really concerned with the issue of threshold. But the inquiry the court is directed to do is to ask whether, because the sign is similar, it produces a particular effect, which is to create a likelihood of confusion. So one isn't asking, in this context, the question, is it similar, as a sort of abstract question? Let's give it to an artist, and what would an artist see as similar or dissimilar? One's specifically asking similarities and dissimilarities for the purpose and in this context. Subsection 3 asks a different question. A person infringes a registered trademark if he uses in the course of trade in relation to goods or services a sign which is identical or similar to the trademark. So again, there's a threshold similarity point. You can't infringe under either 2 or 3. And then it goes on, where the trademark has a reputation in the United Kingdom and the use of the sign being without due cause takes unfair advantage of or is detrimental to the distinctive character or the repute of the trademark. So again, it's established, although the text doesn't say it, but it's certainly established by authority, that the similarity or the degree of similarity does play a part in assessing whether there's one of the detriments, the unfair advantage, or so on. However, it's a different factual inquiry. I think, I mean, this is quite a short point. Now, Lord Justice Kitchen adverted to this in Glee Club, which is in the same bundle of authorities at tab 7. It's page 148 of the bundle. Towards, actually, if I can pick it up at page 1, if I can pick it up at the top of,
yes, probably best to start at 147. Yeah,
the bottom 147. Uh, 110. Further infringement under this provision requires a degree of similarity between the mark and the sign, such that the average consumer makes a connection between them. It's not necessary that the degree of similarity be such as to create a likelihood of confusion, but it must be such that the average consumer establishes a link between the mark and the sign, and this is to be assessed globally, having regard to all the circumstances of the case. And then the fact that the average consumer would, the sign would call the mark to mind is tantamount to the existence of a link. So in my submission, I'd suggest it's clear it is a different inquiry. And then you say, well, is there going to be a link? We have own brand goods sold in a store which prides itself on like brands only better. And in my submission, the consumer is not going to be put off creating a link by the presence of Aldi's house trademark brand name on the goods. That's to be expected. And therefore one would expect the consumer... Sorry, I misquoted Aldi, I'm told from behind. It's like brands, only cheaper.
Yep.
So while certain aspects of the comparison are similar, the doctrine of imperfect recollection applies, because often consumers will come into contact with the mark and sign at different times and places. In fact, within the Aldi stores, they're never going to see the Thatchers product side by side because it's not sold there. So one assumes consumers who've seen or drunk the Thatcher product with an impression in their mind what it looks like coming into the Aldi store, or indeed, for the purposes of section 10.3, opening up a can of Taurus Cloudy Lemon at home. It doesn't have to be just within the store. In my submission, therefore, the more, if you like, the non-dominant elements, or the elements the judge characterised as non-dominant, other than the brand, are going to play a bigger part than they are in the context of confusion. Because in confusion, the, if you like, similarities in surrounding lemons and so on may well be suppressed by the consumer's appreciation of the difference in the brand name. Whereas in the context of calling the product to mind, thinking there's a link, thinking it's a, well, strongest case, a rip-off of it, or at least more neutrally, Aldi's essay at attempt to create their own version of that product, is likely to be much more prevalent, much more important. So in my submission, when it came to the learned judge's last exercise, simply of a roundup, I would respectfully say it wasn't adequate for her simply to say, well, I did an analysis in the context of confusion, and I found there was a low level of similarity. Just to repeat that as a phrase, without reconsidering confusion in the context of section 10, subsection 3. So it's considering similarity in the context of section 10, subsection 3.
Slightly struggling with this proposition, because yes, section 10.2 is looking at whether similarity, it has to be similarity which causes confusion. I'm not sure why, when the judge asked first, is there similarity, and then was there confusion, why is the similarity she's there considering different from the similarity in 10.3?
Well, I would say it's evident from the content of her analysis that she was looking at section 10, subsection 2, and in fact, if I can just look at the issues, are set out.
Yeah, but there's two different questions. One first is the question of law, which is whether the question is the same in both contexts. And then the second question is, what did the judge do? So you have submitted to us that the question is not the same in the two contexts. And if you're right about that, if you're wrong on that, then the next question doesn't arise. But we assume for the moment that you're right about that on the law. Your criticism of the judge is upon that legal proposition. You say, well, it's incorrect simply to translate the finding from one context to the other because the purpose of asking the question is different. That's the submission.
That is my submission, yes.
We have in section 10, we have 10.1 refers to identical, 10.2 is identical and uses similar to, and then 10.3 is identical with or similar to. Why would one, as a matter of statutory interpretation, why would one read identical with or similar to in 10.3 is different to the way it's used in 10.1 and 10.2?
Oh, the threshold questions, they're probably the same. There is...
in both cases, they are precondition,
yes,
aren't they? They are. First of all, you have to find it similar to the trademark, and that has to be the cause of there being confusion. In 3, you have to find it similar to the trademark, and then where somebody has taken unfair advantage. And at the moment, I can't see, as a matter of interpretation, why the similarity either should be read differently or needs to be read differently.
my lord, I think there are 2 points here. One is that these sections specify a threshold level of similarity, which are preconditions.
But they don't.
Well, they
You haven't brought my most recent disquisition on this subject, albeit in the context of similarity of goods, but the principle is the same, where I explained that there's a threshold question of, by reference to previous authority, is if there's no similarity, then you don't get into the subsequent analysis. So there has to be some degree of similarity, but similarity is a spectrum. So once you're over the threshold, the question is there a sufficient degree of similarity to give rise to specified harm? Your case is specified harm differs, and that inevitably impacts on the question of what degree of similarity you're looking for once you're over the threshold.
Indeed, my lord has encapsulated. But I just want to deal with the distinction between threshold similarity and applying the degree of similarity. Threshold similarity, it's conventionally, there's a case called Adidas Salomon in Fitness World Trading, which I think is not in the bundles, but it's actually cited by Lord Justice Kitchen immediately before the passage I read, although not quite to that point. And there has to be some degree of similarity, and certainly Curley cites that same case both on section 10.2 and 10.3 as being dealing with a threshold question.
Once you have passed the threshold, so that it satisfies the test of being similar to the trademark in 2B or in 3, there is then a further question which isn't connected to similarity. It is whether the similarity you've identified causes confusion in 10.2, and it is whether there is additionally unfair advantage in 10.3. There's no further requirement that the similarity be to a particular degree, is there?
Is the point that similarity comes into the assessment of unfair advantage?
Yes, my lady.
That's the point.
It
Because it's a global assessment, and I think you're saying that in making that assessment, you should think afresh about similarity.
Yes, my lady. There are 2 points there. One is that the statute itself doesn't mention similarity in 10.3 in the context of unfair advantage. It mentions it in 10.3a.
Mm.
It's simply as far as the statute is concerned, and the wording comes from the Trademark Directive
Yes.
and regulation, same in this regard.
I can see that if the point is that the more similar it is, the more that might be relevant easier it may be to say that there's unfair advantage taken.
Yes, the authorities, however, say, as far as the wording of 10.3 is concerned, it doesn't direct the court to look at similarity at all in terms, in the context of whether there's unfair advantage or one of the other detriments. However, the authorities establish that the court should look at similarity in that context.
Well, sure, you must look at all relevant factors to determine.
Yes, because it's irrelevant. I suppose if they're very, very dissimilar, and there's only a faint flicker of link or recognition, that might be one thing.
Yeah.
But a more intense.
It's a global assessment, as you've already accepted.
But the second part of the proposition, as my Lord Arnold indicated, is a separate thing, is how did the judge approach it? And my submission is that the judge did approach it, her assessment of similarity in the context of considering likelihood of confusion. And I think I picked that up from starting with her list of issues, which is in the judgment at paragraph 19, page 94 of the core bundle. So the actual issue is issue 2, is the overall appearance of the Aldi product as defined in paragraph 14 of the particulars claim similar to the trademark? And 3, if the answer to 2 is yes, does such similarity give rise to a likelihood of confusion? So it's immediately before issue 3. Then issue 4 is the link. Did it create a link? Now, as expressed as words here, one of course shouldn't use lists of issues, trials, as substitutes for the pleadings, or as, you know, they're meant to be a list of headings, effectively, rather than detailed defining the issues. But as expressed, you could say that's simply directed at the threshold question. Is there enough similarity to get you over the threshold? However, that's not how it was interpreted by the judge, and I don't complain with that, I should say, because within her section,
well, yes, because this is an identical goods case.
yes,
So you've only got the one axis to consider. You don't have both axes.
no, indeed, my lord, which. But her her finding of similarity.
Yes, well, you took us through it.
I took my all through it, but it was all based on the preponderance. It meant she didn't have to repeat the exercise when she got on to issue 2 or issue 3. Does similarity give rise to the likelihood of confusion? She didn't have to repeat the analysis of the similarity in that context. But her analysis is framed in anticipation of answering issue 3 on confusion. I think I've said what I want to say on that ground. There's another short ground before I come to, if I like, the main event. that is the judge's reliance on comparative sales figures of other Taurus range ciders in, if you like, negativing inference of unfair advantage. And that judgment is paragraphs 59 through to 60. It's in a section headed Sales Achieved by the Aldi Product. And at 58, she points out there's to set this up, she points out there's no evidence from Aldi of marketing spend or marketing effort. So it appears they put the product, the cloudy cider product, cloudy cider lemon product in the store without supporting it with any particular promotion, and it's sold. And now that attracted a comment from my client's witness, Mr. Milson, which suggested the figures are astonishing considering Aldi appeared to be no investment, and suggestion of a causal link to Thatcher's own promotion and marketing. Now, the learned judge then dealt with this issue from paragraph 59 to 60, in quite short terms, and she did it by looking at sales figures for the Aldi product, i.e. that product, in the context of the Taurus family of ciders as a whole, in Mr. Watkins' first witness statement. I don't know if actually, perhaps I should turn up that table for. That's in the supplementary bundle. Tab 23. Page number 74, page 74. So there's a table which is produced by Mr. Watkins, Aldi's witness, of sales figures of other Taurus brands, as well as the Cloudy Lemon product, which is the fourth from the bottom.
And in the case of the lemon, it says 2022, but we bear in mind that's from what, 16th of May? So
yes,
it's rather less than a full year's sale.
It's rather less than, in fact, the bulk within 6 months is the evidence, and then there was tapering off because there were residual stocks in the stores.
Yeah.
But it is gone by fairly early in the. All the stock had gone by fairly early on in the new year. Now, I mean, of course, what I do object to on this is the way the judge dealt with this, with, in effect, in my submission, having insufficient material to do a proper comparison exercise based on these figures. true, the Taurus original, which is the second from the top, has very large sales of £19 million over 3 years. But that's their standard original cider, which appears all the time, which appears as a regular part of their range. And what that doesn't give you is any, if you like, trade evidence as to the likely respective volume that one would expect of a sort of, you know, we'll call it a fancy cider, anyway, fruit-flavoured cider, novelty type cider, compared with a standard basic cider. And she then did oh, and there's a further 5 million in 2 litre bottles she mentions. That's at the bottom. Yeah, so a lot in bottles as well. But not comparing like with like, and then she quite briefly deals the Aldi product sales over its short, this is paragraph 60, Aldi product sales over its short life, 2023, 1.6 million in 2022 sales, seems to be in proportion with the 1.4 million sales of Taurus Cloudy Cider in 21, with a runoff in 22 when it was discontinued. Now, Taurus Cloudy Cider isn't a fruit flavoured one, it's just a standard type cider, but it's got a haze in it. About the same level over the same period as Taurus Rosé. Now, Taurus Rosé, again, there was evidence actually of how rosé ciders are made. The course of evidence that they get their pink colour from you use apples with their skins on, which are red, and they derive the pink colour from the skins. And then she says, although higher than another seasonal variant, the Taurus Cherry, I can't see this as disproportionately high given the popularity of lemon flavoured drinks over cherry flavoured drinks. And in the context of the figures as a whole, well, there wasn't any evidence about the relative popularity of cherry flavours versus lemon flavours.
Is this not a case of the judge needing to do the best on the evidence she had available? Because the only response she had to this was a comment by the client's witness that these figures were astonishing or something to that effect. There's no greater interrogation or explanation before her that I could see making the points you're making now.
Well, I mean, but these specific points, which I mean, it's one thing. I mean, it's one thing for the judge to say, well, perhaps I can put the point this way. It's one thing for the judge to say, well, that's Mr. Milton's opinion, and I don't agree it's supported on the materials I've got. That's one thing. But what I would respectfully object to is going further and treating this as some sort of negative evidence. It's actually not clear the judge did treat it as negative evidence, as it were, negative evidence negating the presence of transfer of image, enhancing the saleability of the Taurus product.
Well, here she's just considering the facts.
Yeah.
Not doing any more than that.
But what I'm objecting to is the comparisons, particularly the comparison with the cherry, without evidence as to the relative popularity of cherry and lemon flavours in the trade.
So what do you say she should have done with this table? Just say it doesn't assist? Or
Doesn't assist in this mission.
that leaves Mr. Milton's
Well, that leaves Mr. Milton commenting on these are substantial volumes and there has been no marketing support. And obviously the further point I made here, and I've made in the skeleton, is even when considering the other Taurus range ciders, we've seen the Strongbow resemblance. So in terms of
if the Taurus one's riding on the back of Strongbow, you say that's no evidence of what could be done by Aldi without riding off other people. That's your submission.
That's my submission. You can test it, no doubt. No, I mean, at the end of the day, I do challenge, if you like, the positive use the learned judge made of these comparative figures and the way she deployed them. Quite where that leaves us, on Mr. Milton's evidence, we do have substantial sales in that period. And I put it this way, there's certainly nothing in this picture to negative a normal inference, which I say would be a normal inference given the establishment of the link, that the Taurus Cloudy Lemon product did benefit, is expected to have benefited from expected to have benefited from the link in the minds of consumers.
Would you say that the evidence we saw earlier of consumers on social media and so on is more telling?
That is telling, and in my submission the judge should not merely have said, well, there's a link, the link's established. One thing is to take into account the evidence of the link and the nature of the link.
If the link has caused consumers to choose to buy Taurus Cloudy Lemon rather than another Taurus brand product, is that an unfair advantage?
If they were going to, well, it's certainly an advantage to the brand, but that might not be the case. I mean, consumers might come in thinking of buying a product. I mean, my lord's put to me a particular person, a consumer, who's dead set on buying an Aldi Taurus brand cider of some kind.
Well,
but there won't be.
They may not have been dead set, but at the end of the day, they may have bought Cloudy Lemon rather than Cloudy Cider.
Well, that might be one permutation. On the other hand, there's a consumer who's consumed Thatchers maybe from another store or in a pub, comes into Aldi store, looks at this and says, oh, that looks interesting, I'll buy that. You know, not necessarily wanting cider at all.
Is it right to say that the sales of the Taurus range are pretty much the same in 2022 as they have been in 2021 in total?
The Taurus range, sorry, I'm sorry, my lord, do I need to go back to the table to...
Well, that's what I was looking at.
I
haven't added it up. Maybe you don't know.
Let me look at the table and I'll see if I can answer this point.
You don't have the overall totals, but part of the problem is you're not comparing like with like because there's 4 new products.
Well, indeed, we don't have I mean, the Taurus Cloudy cider, we certainly don't have a complete picture. It certainly looks as if it was in runoff in 2022. The spare two packs or 3 packs sold in the following year.
Yeah, I mean, what it looks like is that cloudy lemon, cherry, and cola replaced some sales in some of the other ranges. There's only so much you can glean from their figures.
Well, it's difficult without a much fuller picture. Oh, okay, yes, I'm prompted by my learned junior that the point your lordship put to me regarding switching brands of cider certainly falls within the threshold. It's a change in economic behaviour by the consumer. Whether that's an advantage or not might depend on many factors, such as different profit margins on the different products. But that's certainly an indication of change in economic behaviour, which was going to be my next topic, moving into the ground of appeal on unfair advantage. Because change in economic behaviour is something that is said to be, in the context of assessing Section 10.3 infringement, one has to either have direct evidence of or infer a change in economic behaviour. But there are differences in different contexts. The European Court's first essay on the need for evidence of change in economic behaviour came in the context of so-called trademark dilution or diminution of distinctive character. And the concept of that doctrine, it's where you have a trademark owner with a trademark and it's distinctive in the market. Consumers recognise it. And along comes another mark that causes it to lose its power of attraction in some way, or diminish its power of attraction. And that's either called dilution or diminution of distinctive character. And there, what you're talking about is some intervention by a defendant in the market which causes change in the future behaviour of consumers. So they become, if you like, less likely to buy the trademark in its product, or at least less ready to recognise it via the trademark. And that is the context in which change in economic behaviour was emphasised in the authorities, first I think in Intel and CPM, which is, that's case C252/07, and that is authorities 4, tab 34, and it's actually, the passage is quite long way in, it's page 1453 of the bundle within the European Court's judgment. And it's paragraphs 76 and 77 of the judgment, where they say, thirdly, as stated in paragraph 29 of this judgment, detriment to the distinctive character of the earlier mark is caused when that mark's ability to identify the goods or services for which it is registered and used is coming from the proprietor of that, as coming from the proprietor of that mark is weakened, since use of the later mark leads to dispersion of the identity and hold upon the public mind of the earlier mark. And then in 77, it follows that proof that the use of the later mark is or would be detrimental to the distinctive character of the earlier mark requires evidence of a change in the economic behaviour of the average consumer of the goods or services for which the earlier mark was registered, consequent on the use of the later mark, or a serious likelihood such a change will occur in the future. So it's in that context that this phraseology was brought in.
Yeah, and they go on 78 to say that in that context it's immaterial whether the user of the later mark derives a real commercial benefit from it.
Yes. So it's a distinct ground from unfair advantage.
Yeah.
Now, my Lord Justice Arnold, in fact, in the Jack Wills case, sought to commented on this issue of economic changing evidence of change of economic behaviour. That is in Authorities Bundle 2. Tab 12, which is
13.
I apologise, I'm suffering from an exploding spring clip problem here.
It's tab 13.
Right. Oh, tab 13. And at, I think, pages 466 and 467. And the paragraphs I have, paragraph 81 to 83. Although it's perhaps 80 to frame 81. Two questions with regard to taking unfair advantage. The first concerns the relevance of the defendant's intention. Which will come on intention, we'll come back to that point. But 81 is the second question, is whether there's a requirement for evidence of a change in the economic behaviour of consumers, or a serious likelihood of such a change. As Counsel House of Fraser pointed out, CJEU has held that proof the use of the sign is or would be detrimental to the distinctive character of the trademark requires evidence of a change in the economic behaviour of the average consumer, or a serious likelihood of third, and refers to Intel, another case. As Counsel for House of Fraser accepted, there's no requirement for evidence of a change in the economic behaviour of consumers of the trademark proprietors' goods or services in order to establish the taking of unfair advantage. Because one's looking at a different category of people. We're looking at basically the defendant's customers in an unfair advantage case rather than the trademark proprietors' customers. And at age 2, Counsel for Jack Wills did not dispute that in order for advantage to be taken of the trademark's distinctive character or repute, it was necessary for there to be some change in the behaviour of the defendant's consumers as a result of the use of the allegedly infringing sign, or a serious likelihood of such a change. Nor did he dispute that what was required was a change in the behaviour of the consumers as consumers of the relevant goods and services, in the sense that their economic, in that sense, in their economic behaviour. He submitted, however, the trademark proprietor would not be expected to produce positive evidence that consumers had changed their behaviour as a result of the use of the sign. And then my Lord concluded, in my judgment, the correct way to approach this question is to proceed by analogy with the approach laid down by the Court of Justice in Environmental Manufacturing, following passage. Admittedly, regulation of the court's case law do not require evidence to be deduced of actual detriment, but also admit the serious risk of such detriment, allowing the use of logical deductions. And nonetheless, such deductions must not be the result of mere suppositions, but, as the General Court itself noted, in citing another judgment, must be founded on an analysis of the probabilities and by taking account of the normal practice in the relevant commercial sector as well as the other circumstances of the case. So I'm taking that as it were, where we statement of the law of economic advantage and evidence of in relation to unfair advantage. And then that brings me, when we talk about logical inferences, to our skeleton argument. I think at this point, if I can run through the skeleton from paragraph 26 onwards, which is at core bundle page
30.
30, yes, 30. Thank you. And the first point made in paragraph 26 is one I've already made in the context of going through the judgment. And our suggestion in paragraph 27 is the findings of a link leading to consumers, the average consumer saying, put it in neutral term, well, pejorative terms, this is Aldi's knockoff of the Thatcher product, but in more neutral terms, this is Aldi's in-house essay to substitute for the Thatcher's product, is on the authority. There are many authorities which have suggested and supported the proposition that when consumers see a familiar trademark, they will be drawn more positively to the goods to which it attaches. And the context in which they see it are points made here, again supported by the findings earlier in the judgment, that Thatcher put an enormous amount of effort, including extensive research, into the chosen design. So it won an award. Secondly, the Thatcher's product bearing the trademark was very heavily promoted, and £2.9 million promotion in its first 2 years. There's an extensive social media campaign, award for the world's best new launch design for 2020 World Cider Awards, and achieved retail sales of 29.6 million in 3 years from its launch. Thirdly, Aldi are well known among their customers for selling own brand versions of market-leading branded product. In fact, they heavily promote under their slogan, like brands, only cheaper. There's evidence reference to that. Fourthly, there was no evidence at all, any promotion of the Aldi product Aldi, put on the shelves in fact sold itself. Fifthly, Aldi initially asserted in evidence that it had only benchmarked against Thatcher product quality, not packaging design. The judge on this sensation is right, found Aldi used Thatcher products as a point of reference. And we add, it was Aldi's only point of reference, there was no other product, lemon cider or otherwise, that they used. Taking design investment used as the benchmark packaging. 28 point out the trademark was well known, heavily promoted, demonstrably highly effective in communicating to the consumer the origin and characteristics of the Thatcher product which it relates. And we would suggest that this is a classic transfer of image case, in the sense those words are used in L'Oreal.
Right, so is this the time at which to look at that authority?
At L'Oreal and Bellier.
We're going to have to look at it at some point.
We are. I was going to come back to that more in the context of intent, but...
well, as you please, but we're going to have to look at it at some point.
well, we might as well start with that because the others follow from it. Yes, ma'am.
Volume 2.
Volume 2, yes, tab 17, which is at page 669 of the bundle.
This is the course.
Sorry, no, this is Court of Appeal. Sorry.
My lords and my lady, it's in Joint Authorities Bundle 4.
4, yes, yes.
Sorry, my skipping to
Tab 35. For those working from electronics copy, it's 14.6.
Thank you.
Apologies for that. No, the reference in the skeleton was to paragraph 41.
Yeah, that's page 1502.
1502. I mean, the context of this was smell like perfumes. And 41, very, very, very well known.
Yeah.
Actually,
You also get more light shed on that by what they say at 49.
yes, indeed. I was going to pick up actually paragraph 36 as an intro, simply because that's what establishes the actual questions whether confusion is necessary. In paragraph 36,
Yeah.
Not such that there's likelihood of confusion. Sufficient, the degree of similarity with the mark and reputation of the sign to have the effect the relevant section of the public establishes a link. And then unfair advantage is 41, where they set out the transfer of image. And I apologise, my lord directed me on to...
Well, I was suggesting that we also get assistance from paragraph 49.
For 49, yes, indeed. Actually, I was going to come back to this anyway on intent, but I might as well. In that regard, where a third party attempts, through the use of signs similar to the mark of reputation, to ride on the coattails of the mark in order to benefit from its power of attraction, its reputation and its prestige, and to exploit, without paying any financial compensation, without being required to make efforts of his own in that regard, the marketing effort expended by the proprietor of that mark in order to create and maintain the image of that mark, the advantage resulting from such use must be considered an advantage that has been unfairly taken of the distinctive character or the repute of that mark. Now, that does involve the issue of intent within that paragraph. It's couched in that way. But if we park that on one side at the moment, and my suggestion is that even if we don't come to intent, the effect of that they've launched a product on the market with no marketing support of its own, it creates a link in the mind of the public with a successful product by clients which has been heavily promoted and supported. So they're not paying any financial compensation to my clients. They're not making efforts of their own. And in my submission, the effect of the link is naturally and in ordinary course to create an advantage.
All right, is that a convenient moment to pause?
That is, because I was just going to look at other transfer image cases.
Fine. So we'll resume at 2 o'clock and let's have a look at the samples during the shorter journey. So if we could have a 4-pack of each and a can of each, that would probably be convenient.
Yes. Handed in that.
Yes, if we could have those now, and then we can take them with us.
Pass them over. Do you want to pass them on? 4-pack of each.
Yeah. You take them separately. All right. You got it?
Very good. Thank you very much.
Thank you.
2 o'clock.